Announcement of judgment. Item for 10.
We do.
Appeal dismissed.
Items 11 and 12.
Appeal allowed. Impugn judgment and order set aside in custody. Appellant shall be released from the jail if not warranted in any other case.
Adjournment request, if any.
Which one?
Yes, please, your lordships. My lord, with the prior consent of the respondent, counsel, I would beg to mention item number 5, my lord. My lord, in this matter, pray for an adjournment for today, my lord.
5.
Yes, my lord.
Okay. On the prayer of Mr. P.H. Kumar,
Yes, my lord.
learned counsel for the appellants. Comma. This the appeal after 2 weeks.
2 weeks, my lord.
Post of the prayer is not objected to by Ms. B. Punya, learned senior counsel and additional public prosecutor appearing for the respondent state.
I'm obliged, my lord.
May I please, Lordship, with the consent of the other side, I beg to mention item number 4. My
Item
senior-
number
4.
4.
My senior is not well, so kindly fix the matter after 1 week.
You are MS?
P. Singh. For the
P.
petitioner.
Singh.
P. Singh.
P. Singh. MS P. Singh, learned counsel.
So I'm for the respondent, Lordship. May I fix the matter on 6 or 8 August?
We'll post it after 2 weeks. P. Singh, learned counsel appearing for Mr. R.K. Talukdar, learned counsel for the appellant. Comma, release the appeal after 2 weeks on a date to be fixed by the office. Mr. P.K. Das, learned counsel for the respondent, has submitted, he is in attendance and has no objection to the same prayer. MS Mozumdar is available.
Are you appearing for R.D. Mojumdar? Yes.
Is he available?
She was available.
She is means having a matter in court number 14, lordship.
Yes.
That was approved. मुझे peaceful को निकल जा उसका।
We have heard it
My lord. That,
partly,
Sakil-
partly and
Yes.
extensively.
Yes.
Because I think one last. The last, yes.
She placed 2 judgments. I have also placed 2 judgments then.
That day,
Yes.
but our brother was not
It was like
available.
that.
No, somebody else. Somebody can Order should be available at two.
At
Two.
yes, Lordship.
Okay. Article of Nimbulan has an- it is up to 21 years. Oh, no, it is a major resolution there. No. 8 years. Into Anglo. Yes, MS Punya, what is this 21 years? Item number 6. Item detention is 21 years. Mr. Prasad, you are 8 years. You are 8 years detention. 9. There is one other matter, 21 years. It is staring at our face.
Yes,
What
the
is this?
consecutive detention.
Huh?
Order of sentence was for consecutive, it was passed consecutive.
Consecutive?
Yes, ma'am.
Item number 6, Your
6?
6.
Yes, counsel is available.
He is under detention of 22 years.
No, you are the arguing counsel.
So, I am the legally considered
Okay, okay.
for that.
You ready?
Item 6.
Mr. Prasad, then. বেয়া লাগে নহয়। Conviction is under what?
302, my lord.
Let us see the judgment part, sentence part. Where is the judgment in the paper book?
Page number 67.
Page number 67. Pune edition.
Conviction is
B পড়া। B পড়া। কোনবা B পড়া? B পড়া কোন? 2003 যে 2003।
conviction is in page number 99. Your
Huh?
conviction is page number 99. Your
99.
Yes. Ten years under section 364. And 302 is here.
Yeah, IPC কোন song?
Judgment was going.
Oh.
Since I could have told making what it was. It will take share billion to me, so because judgment to the whatever is the consecutive rate and for
কোনটা এতিয়া এই সেকশন মোৰ এই বান্ডেলটোত সেকশন 31 ৰ ওপৰত কিবা সেকশন 31 নহয় জানো আইপিসি সেকশন কিবা লিখা আছে নেকি ওপৰত সেকশন 31 নহয় 34 নেকি 30 এতে কনজিকিউটিভ আৰু হেৰিটো যে আইপিসি সিআরবিসি 31 নে কি মজা লাগিছে আচ্ছা 31 আৰু এটা তিনিত কৈছে এই লাইফ ইনভিজনমেন্ট থাকে ইভেন আৰু টাৰ্মছ এণ্ড কণ্ডিশ্যন যদি বেলেগ অফেন্সত থাকে তেনেহ'লে কি কৰিব লাগিব এইটো কমপ্লিটলি দিয়াৰ কোনো মিনিং নাই এনেকুৱা লাইফ আছে কনজিকিউটিভ যদি দিয়ে সৰু সৰু হেৰি বেলেগ বেলেগ অফেন্সত লাইফ থাকিলে বেলেগ কথা বেলেগ বেলেগ দিয়ে দিলে তাক কেনেকে ৰান কৰিব সেইটো মানে ক'ব লাগে এনেকে ধৰণৰ কিবা এটা কৈছে What do you say about this 99, page 99? Paragraph 44.
Yes.
One is 10 years. MS Bhuya, please note.
Lordship,
Also,
Lordship,
MS Begum, both of you. No, both of you.
my,
You as a senior counsel.
my predicament, I was about to do this matter, Lordship, because the Lordship
No,
fixed the
no,
matter
I am
87.
seeking
So some
assistance also.
development, my lord, because the jailer called me up and he said that he wants to meet me, so I thought that I should not appear in this matter.
No, MS Begum also, but
Yes.
you also please assist.
No.
That if suppose it is 10 years, one is 10 years, one is life,
Yes.
and one is 5 years.
Yes,
An order is to run concurrently, right?
yes.
See? Then, if otherwise interpretation is life imprisonment is natural life,
Nature life.
then how this will run?
Lordship. I think.
It will apply to constitution will say it is already multiple sentences divided. Some being term sentences, like 5 years, and one sentence of life imprisonment. That sentences can be directed to one consecutive by specifying that the prisoner shall undergo term sentences first. Then life sentence. I will life sentence to undergo term sentence of prison one. That is one. So, I will have to put in is perhaps a life.
লাইফ তো কাউন্ট করতে এখন এই পারফরম্যান্স তো জন্য
সজীব শেষ হলো তারপরে 10 বছর তো রান করব এইটু গেছ
লাইফ
আপনার পিছর লাইফ এইটু নয়
আচ্ছা
আর বাকিখিনি নাকি multiple sentence of life imprisonment only reward if that same cannot be directed to an they can only done such. Then we rewarded somebody constitution
Section 31 of the CRPC read with section 71 of the Indian Penal Code.
আমি তোমাদেরকে বলতাম Yes, do you have anything to say on this point? Para 44? Because constitution man says that if the order is to run concurrently and the sentences are term sentences and one life sentence, then term sentences will be exhausted first,
Hello.
then thereafter life.
Right.
Meaning thereby, this man will complete 5 years first,
What
then
else?
thereafter 10 years. After 15 years,
Then
his
now-
life imprisonment will run. And that will run till the end of his life.
So it will be 15 plus or it will.
15 plus life imprisonment.
Like,
This is the interpretation of the constitution bench. Right? So that is why Miss Begum and Miss Puya, you have been asked to assist whether this is the correct interpretation or there is any change also. That was, this is 2016 8 SSC 313. It says, if multiple sentences are awarded, some being term sentences, and one sentence of life imprisonment, then sentences can be directed to run consecutively by specifying that the petitioner shall undergo term sentences first and then life sentence. But converse thereof cannot be directed.
Right.
That একটু পঢ়িব লাগিব এইটো যদি এনেকুৱা নাথাকে এইটো যদি দিয়ে এইটো পঢ়িব লাগিব লাইফ সেন্টেন্স প্ৰথমে দি পেলাই বাকী এটা পিছত দিব নোৱাৰে এইটো কমন সেন্সত গম পায় এইটো যদি স্পেচিফাই কৰি নিদিয়ে বাই স্পেচিফিং এইটো যদি ভিতৰত কৈছে নাজানো স্পেচিফাই যদি নকৰে
তেতিয়া order কৰিম।
কনচিকুৱেন্সটো কি হ'ব এটাতো নাই এটাতো
তাতো
চিম্পল
লিখা নাই।
okay so
we'll see.
take this point
Lordship, may I, Lordship, 2016,
16 8 SCC 313
Lordship.
Constitution bench judgment. 5 judges. Yes.
Lordship, my submission, my prayer is that, Lordship. My prayer is that, Lordship. The matter was heard without, there was no direct evidence was there. So he may be under section 400 and
Lordship, in this matter, Lordship, I'll have to go through, Lordship. Just now I have got the file, Lordship. So I'm total, Lordship, 16, there are a lot of witnesses, Lordship. PWs are 16 PWs are there, Lordship.
But we have observed as the appellants are in incarceration for more than 20 years, the instant appeal requires expeditious consideration in the previous order. Yes, what is your submission?
may go for page number 88 of the judgment. Your Honor. Para 33, Your Honor. It is said there was no direct evidence against the accused person. In fact, none of the witnesses examined by the prosecution saw the accused persons to commit murder of Rantu Sharma. Accordingly, Your Honor, in further lower court found that
This is a case of circumstantial evidence. And court has
as
authored the judgment after appreciating the evidence.
that is true, but Your Honor, the first evidence, the
As an appellate court, we have to
Well, yeah.
go through the entire evidence. We cannot read from the judgment.
but my submission is there was no direct evidence was found
Or
and no authorship of letter was proved. So he.
we don't know ABCD of anything, madam. We have opened the case. How can I know? We are going through the evidence, materials on record. We only found that
Going
they were in custody for more than 20 years.
since 2000.
Right.
Yes.
We had only observed that much. We have not gone through the records. You have to take us through the records. Is it not?
Yes.
You cannot point out to paragraph 33, no direct evidence, acquittal. How can it be possible, madam? When there were 16 witnesses examined, how can you say that? This is your first appeal. hearing,
Yes, my lord.
first criminal appeal hearing. 16 witnesses, madam, so many exhibits. You cannot say that paragraph 33 direct evidence. Court has discussed the circumstantial evidence and found that the chain is complete. A boy was kidnapped and he was murdered. Is it not?
Yes, my lord.
Then how can you, by paragraph 33, you can say? First criminal appeal hearing. Actually, this kind of, how many years of experience?
From 2002, Your Honor.
2. Okay, otherwise murder cases are to be heard by, conducted by 10 years. নতুন। We are helpless then. MS Begum is also not prepared.
Just now, I got it.
Equally better. নামিয়ে sound again. Okay. Let us go one by one. Hmm? Okay. Only other. Okay, let us start from the FIR. We'll help you. We'll assist you.
Pardon, Your Honor.
Start with the FIR. Oh, you
Your Honor.
started 2. You better start at 2. In the meantime, you go through the,
Okay.
what are the vital witnesses? Who are the vital witnesses? How many appellants? 2.
Two.
Suppose if the appeal is to be allowed, then these persons are more than 22 years in jail. Serious, madam? You have to be serious. Okay. Right there. Last scene. Have you prepared your case on the basis of last seen together theory? Recovery of ransom letter, section 26 of the Evidence Act.
No, I will pray for another date, Your Honor. Let me be prepared.
Recovery of dead body on the basis of section 27 Evidence Act 313 CRPC.
Let me go through that and give me a pardon.
If you do not satisfy on the next date that your preparation is not up to the mark, we will replace. We are making it clear. Yes, madam. See this part, consecutive part. And whether this appellate court has the power to modify the sentence, right? And in what situation? Mitigating circumstances and aggravating circumstances, right? From Bachchan Singh onwards. MS R. Goswami, learned legal aid counsel, has submitted that the appeal be listed after a week, as she could not prepare the brief. So a similar prayer is made by MS A. Begum, learned additional public prosecutor for the respondent state. Post stop. As the prayers are made by both the sides, this appeal stands adjourned for a week. Post stop. Please the case. appeal after week on a date to be fixed by the office after week. পিছত দিব আৰু লাগিব বেলেগত লগা হয় নহয়
Lordship, this Duffy case, Lordship. Today also, I could not get the A, but what Devlin just said, I could quote that, I could get the quotation. But maybe in the judge's library, it will be there, Lordship. That is on provocation. Provocation when, Lordship, should I go by the case, Lordship? The person he killed his mother and he made a confession statement. Lordship heard it on last. Or else I'll read the FIR, Lordship, just to refresh, Lordship.
There was a confessional statement, right?
Yes, Lordship. Confessional
Let
statement.
us go to that first.
Yes, that is page 74, Lordship. It starts from 74,
Oh, God.
but the main
What was the
confession
date
is,
of the commission of the offense?
date was 30 August.
30 August.
You surrendered. Confession, main confession is at page 79, Lordship.
So after 4 days of arrest, right?
Yes. He himself went to the police station, Lordship, after committing. So
Then what was he was sent to judicial custody or not?
the magistrate we adduced evidence.
Magistrate was examined?
Yes, Lordship, that is at page 28, Lordship. Should I read, Lordship?
Hmm.
He is PW 15, Lordship, Dr. Ankur Bhuyan. On 9/1/2017, I was posted as Additional Chief Judicial Magistrate Udalguri. On that day, learned Chief Judicial Magistrate Udalguri directed me to record the confessional statement of accused Hiranya Khanda. Accordingly, Hiranya Khanda was produced before me on the same day. After that, the accused was explained that he was not bound to make confession and that if he does so, it may be used as evidence against him. After that, the accused was remanded to judicial custody till 4/9/2017 for reflection. Accordingly, on 4/9/2017, Hiranya Khanda was produced by the investigating officer and he was again explained that he was not bound to make confession and that if he does so, it may be used as evidence against him. However, the accused stated that he wanted to make the confession. Hence, the accused was placed under the supervision of Dinesh Datta, bench assistant, for reflection in the room of steno. On the same day, accused was again asked as to whether he wanted to make confession or not, but the accused stated that he wanted to make the confession, and then the accused was explained that he was not bound to make confession and that if he does so, it may be used as evidence against him. After that, as it was found that the accused wanted to make his confession voluntarily, the confession was recorded in my presence and hearing and also read over to the accused, and the accused admitted that the statement is correct. The confession contains a full and true account of the statement made by the accused Hiranya Khanda and in a fit state of mind. Exhibit 6 is the confessional statements. Exhibit 6(1), 6(2), 6(3) are my signatures. In cross, he says, the accused was first produced before me for recording the confessional statement on 1/9/2017. On being asked, the accused said that he was suffering from ailment. I did not record the confessional statement on 1/9/17, though he was willing to make such confessional statement, and accordingly accused was directed to produce before me on 4/9/2017. Again, on 4/9/2017, accused was produced before me for recording his confessional statement. I was not bound to provide legal aid to at the time of recording statement of accused. I did not take the signature of the accused in any of the pages of the confessional statement recorded by me, White Exhibit 6, Lordship. Lordship, this confessional statement is there, but I have gone through, though I think I cannot use that 161 statement. That statement was made by the accused. And the language there, what he alleged that his mother used, Lordship, is like for ordinary person, that is quite provoking, Lordship. Me and Madam Bernali also, we went through that.
Your lordship, on the last occasion, Peru's the ones, just for the sake of seeing my lord, your lordship seen the 161 statement. Yes.
I cannot use it, Lordship, but then, yes, it cannot be used, Lordship, but then the language which is used in this 164 is not covering whatever was told before and in his 313 statement also, he said that I said as per the police version. And I think the main defense they wanted to take was total denial, but this was not a case of total denial, Lordship. What if we go through so can something be done on, that's why I was on provocation, Lordship, that Regina versus Ahluwalia, last date I submitted that judgment, Lordship. And that was, that came up with the case of Regina versus Duffy. This Duffy judgment I could not get, Lordship. In that, the provocation part is
161 statement
cannot be, Lordship.
that Regina, whatever, Tehsildar Singh, 1958 or 60, Supreme Court is clear. Only for the purpose of contradiction,
Contradiction.
no other purpose.
Corroboration and contradiction. I get it.
Not corroboration.
Contradiction.
Not
yes, yes.
corroboration.
No. Contradiction.
Tehsildar Singh is clear.
No, in fact, when I searched Lordship,
So-
23 also judgment came. Justice Sapre and
Tehsildar Singh is loud and clear, 5 judges bench. That was for the purpose of benefiting the accused. The proviso intended to serve primarily for the interest of the accused. The section was conceived in an attempt to find a happy via media, namely while it enacts a absolute bar against a statement made before a police officer being used for any purpose whatsoever. It enables the accused to rely upon it for a limited purpose of contradicting a witness in the manner provided by Section 145 of the Evidence Act by drawing his attention to the parts of the statement mentioned in the for contradiction. It cannot be used for corroboration of a prosecution or a defense witness or even a court witness, nor it can be used for contradicting a defense or a court witness. Shortly stated, there is a general bar against its use, subject to a limited exception in the interest of the accused, and the exception cannot obviously be used to cross the bar. So only for the purpose of contradiction, not even for corroboration. So
yes, that contradiction.
any other principle will
That's
fall by the side,
correct, Lordship. That's why
even in any English law also.
no, English law I'm using to see the word provocation, because in the FIR itself there is altercation word is mentioned, and in his 164 statement also he said that there was a quarrel.
Yeah. Yes, it was. Page 28. I don't have little Sukuya. 28. Last time. Competition code. It will. One sixty for reference করা আছে 81 81 যদি কোন একটা ক্লিকিং হয়ে যাচ্ছে নিম্ন হলে যদি দিতরি then it goes it will be there for the sign. Like it should be shown and based on the accused. And if it does not understand the relation to the events, then it will do that. Now you should do that means to fail. Who says that?
I said you send that I said.
Based translate. It is not Complicated to do. What's high level? পুলিশ admissible না হলে admissible হলো effective হলে witness আছে আরো সারেন্ডারও আছে Other than 164 statement, what are the other incriminating evidence
There
against
is
the
no
accused?
eyewitness as such, lordship. But
Which one eyewitness?
No eyewitness, but
No eyewitness, few chowkidars of the tea estate
they
came,
came later.
found the body lying in the bed
Yes.
with a weapon of assault, alleged weapon of assault lying by the side. Right. But there was one witness who
Yes.
said that the disease visited him.
11.
Her house, and she is Sanika Kedia. Page 23.
Page
23, lordship.
Oh. Where from it can be seen that the deceased was, the accused was in the house.
In the
Who had said?
Any
witness said that he was in the house that night?
No, everyone actually, what they did is they came later on. Only this witness, lordship, 11, She said that the accused used to live with his, and one of the witnesses,
Because
remember.
PW 11 in
Okay.
cross said on the previous day of the incident in the night, I did not meet the accused.
No, one witness, I think, one witness, Kibata Asil, no? Ludo. PW 12 lordship that he, with him, the accused was playing Ludo game and then he went back to his home. I felt sleepy. I had to go to his home at about 9 p.m. and left for his home, which is situated adjacent to my home.
Itu in general accused was staying with her mother because এই মামাকে তো এইখিনি কৈছে কেনেকে তাই মাকে গিৰিয়েক ঢুকোৱাৰ পিছত আকৌ এজনৰ বিয়া কৰালে আকৌ এজনৰ বিয়া সেইজনো ঢুকালে আৰু sister and her son were living together বুলি ক'লে এইখিনি ক'লে sufficient হ'বনে নাই যদি এইটো sustain নহয় এইটো মেইন সারেন্ডার এইটো আছিল এইটো ৰিমুভ হৈ যায় সারেন্ডাৰটো থাকিল এইখিনি থাকিল নহ'ব কন্ডাক্টটো এটা হ'ব কিন্তু চেইনটো ক'ত থাকিব আয়ৰ যিটো কথা দেখি আহি পেলাই দাখনো পৰি আছে বুলি কৈছে Because you know, the Dao by means of which he can't the nail of the was lying beside. It was over the packet police. Over the packet police. It was recovery government. Like those circumstances, only one circumstance is behind itself. PW 11 তিনি কথা দিলা করে না নাকি মাকে বুঝে দিই ধমকি দিয়েছে তো পুলিশের হবে MS Bhuya, what is the implication of this statement? What is the magistrate's statement? PW?
11.
No,
11.
no, 15,
15, sorry.
15, page 28,
Page 28A.
28 and 28A.
Last line, cross. I did not take the signature of the accused in any of the pages of the confessional statements.
May not be necessary, madam.
Why?
May not be.
Have you read 164?
Oh. 53. Oh, Lordship, 160. Lordship, I have found some judgments.
Read first. Read it. Question is very pertinent. Nobody has addressed. Okay, we should know.
I read 160.
Read yourself
Yes.
at peace. And read 164 subsection
4.
4. Right. Subsection 4. Now
Shall be
go,
signed by the
now turn to section 281.
person. 281.
And this is specific to the accused, right? Subsection 4 and subsection 5.
Lordship, it should be read over to the accused person. And it
There
should
are
be
the
interpreted to him
Signed.
It shall there have to be signed by the accused and by the magistrate or tenant, who shall certify it under his own hand. Like lordship.
Hmm.
It is there.
Tell me how, by a judgment, exception can be taken. Or it is directory. It is held to be directory. If it is held to be directory, okay.
Mandatory.
Lordship.
Otherwise,
Mandatory.
shall.
But sometimes,
Sometimes then show us authority.
to that effect I did not bring, but I got,
Otherwise,
my lord,
if this goes,
my lord,
what remains? The act of surrender
act of surrender.
and PW 11.
11,
Nothing else.
lordship.
Otherwise, 164 reflection time, 3 days. Then after appearance of the accused before the magistrate, reflection time was also given separately. Procedure followed,
My lord.
but this part of the procedure was not followed.
Let us see. the
And
original, my
admitted,
lord. Original
admittedly,
lordship has found.
I have seen no signature. And admitted by the magistrate himself or herself. So what will be the effect
Effect,
or consequence?
my lord,
MS Mazumdar has not argued it.
my lord.
Lordship, I am on
This is
that
very
only.
No, we have heard you enough. But you have not raised the point till now.
Yes, I accept it.
If it is held to be directory, it is okay.
My lord.
No, it is mandatory, Lordship.
No, now you are saying.
No.
Now you are saying. We are
No, I
normally,
was-
we normally take whenever it is shall, it is mandatory.
In all
But
the four sections,
This point has come suddenly. That is why we are giving time to MS Bhuiyan to recover.
No issue, Lordship, no issue. Because I was taking in a different line, but this is more helpful to the accused.
Because your grave and sudden provocation under exception 1, you cannot take the benefit of 161. Then after that, there is nothing.
And the other part, the
This part goes, this PW 11's testimony goes against you.
True.
Because when there is sufficient time to regain the composure by the accused, there is a time gap. Right? If there is a time gap, then exception 1, even by Nanavati,
But Lordship,
will not come to your rescue.
no, if there is
And
mistrial, Lordship,
subsequent judgments.
if there is mistrial, if this
Today also I have got
164,
one on
Huh?
provocation part. Provocation, I have got one judgment, your lordship,
No.
because their schooling period was there.
Huh.
Lordship, if what I was saying is that
Grave and sudden.
sudden provocation, yes, Lordship. But
If
the thing
that,
is, if there was a
if
mistrial,
that extramarital relationship was existing.
not only extramarital, Lordship, if we go by 161, of
No,
course, I
no,
cannot
no,
use.
No,
I
no, no,
cannot use.
Ms. Mazumdar, please don't go to 161.
Yes, Lordship.
Which is barred is barred.
Yes, Lordship. But the thing is, Lordship, if there was a mistrial, if this magistrate did not do the thing properly, there is a mistrial.
No,
So
Ms.
Lordship,
Uh,
send it back for
no.
a
that
proper
is the-
trial. There is
that
a
is-
mistrial, Lordship. Because from the very beginning, he himself, after the act, he himself goes to the police station. He surrenders that he did the act. Maybe what I feel, Lordship, maybe Lordship will differ from that in a fit of moment, he did the act, but then he had the remorse, he goes to the police station and he himself. Otherwise, there was no evidence that he has done.
Whatever the IOCs, except the act of surrender, other parties, whatever was disclosed by the accused before him, which he did testify, is not admissible because of section.
Exculpatory and inculpatory. That is true, Lordship. But then if 164 statement, the evidence of magistrate, Lordship, my humble submission will be it is a mistrial because from the very inception of the case, he is.
It is not case of mistrial.
No. Then, Lordship, the mitigating factor, Lordship, that provocation, exception, I have to stick to exception 1.
Exception 1, if 161 statement to the. Yes, MS Bhuya.
One day time we granted. Lordship, I'm trying to find out
Miss
from my mother.
Bhuya was under the impression that she had a very good case.
I thought so much. Because Lordship's query on the others, Lordship did not go into this aspect.
No,
of the matter.
suddenly we read,
Lordship.
suddenly we
My lord.
checked 164 and 281.
My lord.
Retracted in 313.
He retracted. He said that it was because of the police. Yeah, I said.
Oh, Lordship found one.
Yes,
It is 2001, 2 SCR, SCC to Aseniki. 2001, 4 SCC 9. Dhananjay Reddy versus State of Karnataka.
Karnataka. Niranjan was West Bengal. But this line was specifically extracted in the cross-examination.
Yes, Lordship.
Specifically extracted in the
the
cross-examination.
Yes. The
And
signature.
I had marked it, Lordship. I do not know why that day I did not, and I had marked it as important. And he's quite arrogant in that. I was not bound to provide legal aid at the time of recording statement of the accused.
But right.
Lordship, para 17, before ascertaining the legality and admissibility of Exhibit P77, it has to be borne in mind that the confessional statement of A4, which was recorded by Shambulingappa, the then CGM Bangalore, has not been signed by the said accused. The High Court also found that we do hold that the same was not recorded by him in strict compliance of Section 164. It is further to be noticed that the confession statement was made by A4 in Tamil language, which was recorded in Kannada script by PW50 with the assistance of his stenographer, who knew both Tamil and Kannada language. The aforesaid stenographer, however, has not been examined as witness. Before recording his statement, the magistrate appears to have put some questions to him to satisfy as to whether the statement being made was voluntary or not. After being satisfied about the voluntary nature of the confessional statement, PW50 recorded a statement which was admittedly not got signed by A4. Learned counsel appearing for the accused person have admitted the compliance of all the provisions of 164 of the CRPC, except the LS violation of not getting the signature of the accused on his confessional statement. It is worth noticing that in the statement recorded under 313 CRPC, A4 denied of having made the confessional statement Exhibit 77. Then Section 164 has been quoted. Then Section 281 of the said code prescribes the mode of the examination of the accused. Subsection 5 thereof provides it shall be thereafter be signed by the accused and by the magistrate or presiding judge. The function of the magistrate in recording confession under Section 164 of the code is a very solemn act which is obliged to perform by taking due care to ensure that all the requirements of Section 164 are fully satisfied. The magistrate recording such a statement should not adopt a casual approach as appears to have been shown by Shambulingappa PW50 in this case. Besides, ensuring that the confession statement being made before him is voluntary and without pressure, the magistrate must record the confession in the manner laid down by section. Omission to comply the mandatory provisions, one of such being as incorporated under subsection 4 of Section 164, is likely to render the confessional statement inadmissible. Then thereafter, maybe it may come in my favor. The words shall be signed by the person making the confession are mandatory in nature, and the magistrate recording the confession has no option. Mere failure to get the signature of the person making the confession may not be very material if the making of such statement is not disputed by the accused, but in cases where the making of the confession statement itself is in controversy, the omission to get the signature is met.
Here he
Fatal.
retracted.
Fatal.
Fatal when he denies the correctness of the
Hmm.
statement.
When he,
313, he
Yes.
denied the correctness.
in 313, what he said?
He,
Question number 9.
Hmm. 37, police course tutored.
But your lordship, what, कितने एक पूछ सकता था? 3132?
37.
37.
30 ಕೂಡ ಅನ್ಬೋದು.
Success citation.
কোনটো?
Citation.
313 to evidence of পিছত লৈছে 19 ত লৈছে. Because he's saying in answers, it is not a fact. I mean, I only went to the police station to inform the police about the incident. And to question number 19, he says, I'm innocent, police coerced and tortured me to make confessional statement. Huh?
Full data.
Date to তোমার হেৰি 5/8/19. এইটো তো হেৰিৰ পিছত হৈছে 30 Oh, মানে after how many years? Huh? So it's that incident. You want to say they did not take a 17 or 19 within that 2 years.
Lordship, then it may hit section 463 CRPC.
Hmm? How? What is there?
Not
460.
with provision of section 164 or section 281
164?
or section 281.
Appeal. No, it's 62 to something. Obedience second sound. Obedience second.
Take evidence in regard of such non-compliance.
The judgment you have read,
Lordship, the
the
judgment.
judgment,
Oh, it's
you
gone.
read the next paragraph.
Lordship. No, Shiva, it's gone. my lord.
Rate 2001 4 SCC 9. Dhanraj. Dhananjay. Reddy. Oh, wow. 2001 4 SCC.
Oh, Dhananjay Reddy, instead of
fine.
another. Lordship, which paragraph?
The paragraph you have read, next paragraph.
Answer.
Dealing with a case where, Lordship, that is,
Hmm.
dealing with a case where the magistrate was found to have not complied with mandate of subsection 2 of section 164 of the code, this court in Kehar Singh versus State Delhi Administration, 1989 Criminal Law Journal 1 held that the compliance of subsection being mandatory and imperative is non-compliance renders the confession inadmissible in evidence. Such a
Next line.
defect, yes.
Next line.
Such a defect cannot be cured under section 463. My lord.
Huh?
That is correct. Gosh.
Oh, it is subsection 2, non-compliance is subsection 2 of section 164.
Oh.
What is the compliance?
Section 2. The magistrate shall, before recording any such confession, explain to the person making it that he is not bound to make a confession. And if he does so, it may be used in evidence. Lordship, I think it's there in our high court, that form is there, my lord. All those things are there.
Section 4. The next sentence itself is there, Lordship. We have no hesitation to hold that compliance of subsection 4 of section 164 of code is mandatory. And it's, the subsection 4 is that, Lordship, signature.
Then it proceeded for further discussion.
If one part is
Then it
Not-
went on.
the entire confessional statement in all its part, including the admission of minor incriminating fact, must be excluded unless proof of it as permitted by same under section 27 of evidence.
Then para 21 goes in my favor.
To view. Okay, follow it, it's paragraph, but it's into follow it. The defect cannot be cured. We have no hesitation to hold that compliance with subsection 1 is medical. Its non-compliance renders the confession not admissible or reliable. It is a simple question for Apollo available. Apollo will have further discussion for each other. 27 evidence actually. Go Ako prayer 22 section prayer to 22. Prayer 22 key pieces. Was it on Nagpur? I don't need to give
The accused himself admitted that he made that particular.
But an omission to obtain signature of the accused to the statement under section 164 would not vitiate confession where the accused himself has admitted that he made that particular statement. You don't Nagpur. গতিকে টুকিং করে করার পিছনে ট্রান্সপোর্ট থেকে অর্ডিটি রিপোর্ট নাকি তাৰপিছত fourth line, and the magistrate taken due care and applied his mind by referring to the clear provisions of section 164 CFC, such a glaring illegality in recording the confessional statement would have been
Magistrate to
avoided.
গালিও দিছে ইয়াতে।
View of this finding, no reliance can be placed upon the judicial confession allegedly made by A4, particularly against A.
Extrajudicial
We
confession.
examine the matter from a different angle as well as by not as a, but as a extrajudicial confession.
এই তার তলৰ প্যাৰ।
Ultimately, কি হল কৰিলে এইটোৱে তো হল কৰিলে তিনটা lapses in investigation, failure of the judicial officer to record a confession statement in accordance with law, and absence of corroborative evidence leaves us with no option but to give A1 the benefit of doubt. Moral conviction regarding the involvement of an accused in the commission of a crime cannot be a substitute for a legal verdict based on facts and law. আমি একটু কথা বলছি। Though with regret but bound by law. With regret. Tomorrow it will. But bound by law, we have no option but to set aside the value. It completely goes against you, the judgment. Dhananjay Reddy.
Suspicion
Oh,
cannot
it will- Paragraphs are there. Lordship will.
No, I have read,
Judgments,
we have
yes,
almost read up to
My
page
lord.
paragraph 27.
My lord.
3 factors: lapses in the investigation, failure of the judicial officer to record the confessional statement in accordance with law, and absence of corroborative evidence leaves us with no option but to give A1 the benefit of doubt. Moral conviction regarding the involvement of an accused in the commission of crime cannot be a substitute for a legal verdict based on facts and law. Though with regret, but bound by law, we have no option but to set aside the judgment of the third court and the high court.
I'll search my if I find
Oh.
something. Subsequently,
Only till tomorrow 10:30. Otherwise, if it is set aside, otherwise it
Then
will be
the-
holding the field.
Lordship,
Otherwise, it will be holding the field.
I know.
Because if this 164 does not remain in your support, then what remains? That the
surrender
act
part-
of surrender, only the act of surrender,
Yes,
whatever he disclosed after surrender to the IO, that will not be admissible. Hit by 25-26.
yes. No, that will not be covered.
And plus the Dow, even if we say the Dow,
My lord.
Dow was this Khaturam or Maturam, somebody, he already saw the Dow.
That apart, my lord. Lordship.
Please come to this one, Khaturam or Maturam, somebody was there.
They were different.
No,
No,
one particular.
At the weapon itself was differently.
No, 1 minute before the Gola Munda, PW5.
15.
Ola Mundas. Yes.
He visited at very first point of time. And he saw the Dow already. It is not a fact discovered.
No. Then your lordship that the accused person threatened,
Dow was sent for serological?
No.
No.
but accused person threatened the victim. She went and reported to PW11.
Yes.
Suspicion,
previous
that
day-
might raise
Oh.
suspicions.
Okay, act of surrender, 1.
And this.
One
this-
circumstance.
Yes,
Then PW11.
my lord.
That DG said that he was threatened. And the third, might be that accused and deceased were living together. I think this is the more three circumstances.
But on the, that
But
your lordship
it
is
was not a
correct.
case of last seen
No,
together.
not there. That
It was not a case of
yes.
last seen together, right? They were staying. That does not mean
The relevant point of time, he was present at his residence.
that will not, we
Leave it
cannot.
to Lordship, my lord, because if, lordship, we should not see the 161. There is a part of grave and sudden
That,
provocation.
that,
Lordship, your lordship is handicapped. But your lordship,
I have
apart-
read already Tehsildar Singh.
yes.
And then
still
PK,
holds the
PK,
claim.
PK, Tripathi or something like that.
That-
Mishra.
Mishra.
It says, no, don't. Court also cannot look into 161 on its own.
I know.
The recent judgment also is there on 161.
So
Then leave it to lordship. জেলোতে আছে নেকি?
জেলতে আছে চাগে কিন্তু
it will be
70 নকওঁতে মই সেইটো কথা নকওঁৱেই জেলত কেতিয়াবা
64, 281.
কেছ হিয়াৰিং কৰি কোনফালে যায় last line. I came with something provocation. There is 161 to market, so that signature is not needed. That is very important.
Last thing together or not?
Last and together.
Moral conviction, legal conviction. Those two will not.
Lordship, I kindly have a look at this. It may go
Anything?
in their favor. Saran Singh Ratan Singh.
About me sufficient.
Two things. One is voluntary nature. Secondly, truthful.
Truthfulness.
If voluntary nature falls, truthful
Also
will
will go.
automatically fall. Now here 313 he says, plus it is inadmissible because of non-compliance of 164, 4 and 281, 5. Supreme Court judgment. But confession does not remain. Then there is no question of retracted confession.
Lordship,
Okay. Anyway, we'll take note. 1957.
Lordship can take the matter on Monday.
Not
Oh,
Monday,
bench
this
is
bench
not
will not be
available.
sitting, only up to 10:30. If you really want,
Lordship,
only 10:30 tomorrow,
Because
because Monday, this bench will not be sitting.
I leave it to your lordship.
It is up to you. We can,
কালি ৰাতিপুৱা
if you want to make the research,
ময়ো কেইটামান চাই আহোঁ বোলে।
Till second half, your lordship is not sitting tomorrow.
sitting,
I'll not say 10:30 because I'm having, my matters may come, but I'll try to find out if I find some.
So we come then.
No, anytime, maybe.
Actually, then I don't have to do no, 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 no.
if anything against the judgment, this Dhananjay Reddy,
I know,
which you have cited, anything against this Dhananjay Reddy
my lord.
is there, it is distinguished or reversed by any larger bench,
My lord. Then,
then it is,
Right.
otherwise it will hold the field.
my lord. Or I can give it to the bench clerk.
You mention it so
Right.
that আমারও escape notice No? First, MS R.D. Mojumdar, learned amicus curiae for the appellant, and MS B. Bhuiyan, learned senior counsel and additional public prosecutor for the respondent state to stop on the prayer of MS Bhuiyan, who wants to make some additional submission. Come on, list the case again tomorrow.
Highly obliged.
Single. Oh, that's very good. Oh.
Item number 1.
It is against bail
Conviction.
rejection or final judgment?
Final judgment, conviction.
Possible to conclude one or not? Yes, Mr. Dev Chaudhary.
We also
Problem
told you that-
is that this bench will not continue. Next, from Monday onwards. So, huh?
It will not be completed today.
Parter will be difficult.
difficult, man.
Had it continued, then we could have started.
In any case, Lordship, I would not be there in the next week. I was telling you.
Oh,
So let it be after 2 weeks, man.
after 2 weeks. Against final judgment.
Against final judgment.
আপোনাৰ নেকি? নহয়। কাৰণ, where is the judgment?
131.
Page
Judgment is at page 106
106.
and
Conviction
conviction is at 130.
129, 130.
Okay, what is it?
Life.
Okay, what is it? Okay. As sought for by Mr. B. Prashad, Learned Counsel for the single appellant,
Single appellant.
and Mr. R.K. Dev Chaudhary, learned. It will be PP or what? Stability Solicitor General Meeting.
Yes.
For the respondent, I release the case. You will not be present next week,
Next week, Lordship, some case matter
Okay.
is going.
2 weeks,
In the week commencing 29th.
Okay.
it will be.
2 weeks on a date to be fixed by the office. Since it is 8 years, it will be listed.
Item number 2.
Your lordship, senior counsel is on his way, my lord.
Yes.
I think it.
Appeal against acquittal. Appeal against
Yes.
acquittal. Oh, people. विनी को गिरे के मारा नहीं गिरे को विनी के मारे Double presumption.
My lord, not, acquittal is not on basis of the presumption, my lord.
No. First principle is that a person is presumed to be innocent
My lord.
till he proves guilty.
Uh,
Then thereafter, second presumption. When trial court
yes,
acquits it, then it is double presumption.
a double presumption is, my lord, here it's beyond all reasonable doubts, my lord. That is a concept, my lord, which in criminal jurisprudence has to be taken. Now here your lordship will find the case in nutshell is this, my lords. On 25/8/2012, that is the PW1 sister of the deceased, is it? Lodged an FIR stating that on morning his brother has been murdered by electrocuting by his wife, my lord. Support of his case, my lord, as many as 8 witnesses has been, my lord, examined, including the IO as well as doctors, my lord. Now, out of which, my lord, there are as many as 5 eyewitnesses, 6 eyewitnesses. And, my lord, there 164 statement has also been recorded, my lord. Now, the acquittal is on the ground of that medical evidence does not tally, number one. And second is that there's a contradictions of PW1s. That is the only thing, that is in paragraph 12 only, your lordship will the finding of the trial court, my lord. Now, if your lordship will kindly see the FIR, which is at page, my lord, in the paper book, my lord, if your lordship can see, that is the Ajahar. The FIR is at page, my lord, 3 of the paper book, my lord. Now, what it says, sir, with due respect, I beg to state that at 7:30 a.m. today on 25/8/2012, Hitendra Dihinga of Rangaigaon was electrocuted to date by his wife, Srimati Dipanjali Kholikar Dihinga. After plugging out the plug of the inverter, she threw it to her husband, Sri Hitendra Dihinga, thereby causing his death. She had been torturing him both physically and mentally for 2 years from today. In addition, she had also been torturing elder brother and younger sister of the Hitendra Dihinga. The matter has already been intimated to the police of the Borbora police station on 22/8/2012. A complaint was also lodged, which Women Cell Dibrugarh Sodar police station to this effect that on 24/8/2012, he filed a divorce case for the torture meted out to him by his wife. In this regard, Milon, the local persuaded Srimati Dipasali Khonikar to maintain peace. Dipanjali, it should be Dipanjali Khonikar to maintain peace and orders. She did not pay heed of the public. Dipanjali Khonikar, mothers, Srimati Lavanya Khonikar was also involved in this matter. I therefore requested.
Okay, during the trial,
my lord, my lord,
any evidence was laid regarding intimation to police, Borbora police station?
No, it is not.
No. Then that regarding any complaint lodged before the Women's Cell? No. I'm asking just
yes, my lord, but
to cut short.
cut short, my lord.
And then regarding divorce case,
Divorce case,
filing of divorce case by the husband,
by the husband, my lord, that has not been stated.
any
before the-
evidence?
No, not evidence, if your lordship kindly see, I'll come to that, my lord.
No, that's why I'm asking, any evidence?
Evidence, my lord.
Oral documentary,
Yes, my lord.
oral was there.
Why this has been made, this is because of the fact of this, that he was, that you have to see the motive, my lord. What is the-
Anything about local persuading Dipali Khonikar to maintain peace?
My lord, that was not in the evidence, but if your lordship kindly see the
And
earlier this thing,
fifth, any involvement of her mother?
not like,
So out of 5
my lord,
allegation in the FIR,
my lord,
these 5,
My
there is nothing.
my lord.
Okay.
Now, your lordship will kindly see, then your lordship has to see the Evidence of PW, that is a complaint, my lord.
Okay.
PW1, which is at start at page, my lord, 7, my lord. Now, I know the accused person. She was married to the deceased, Hitendra Dihinga. I am the complainant of the case. On 25/8/2012, at around 7 o'clock in the morning, my brother Hitendra Dihinga died. Accused was the wife of the deceased, Hitendra Dihinga. On 25/8/2012, I was standing in a room of our house. There was a table on the room and there was an inverter near the table. My deceased brother at the time opened the drawer of the table and brought one box of tobacco. At that time, the accused came into another room. Accused removed the connection of the inverter and electrocuted him with the live wire. It should be live wire, my lord. At that time, the accused was quarreling with the deceased and with us. As a result of which, my brother fell down on the floor of the room and shouted, and after some minutes, he died. At that time, the accused shouted that whether the accused deceased died or not. Then I made hue and cry. The accused also threatened me to kill. And after incident, and accused locked herself in a room of our house. When I made hue and cry, the neighboring people gathered at our house. Village people informed the police about the incident. And after some time, the police came to our house and took the dead body at first to the Borbora police station. And after that, took his dead body to the Alham Medical College for post-mortem. At the same time, our unmarried elder sister, Moina Dihinga, an accused, resided in the house. The accused always threatened us, demanded us for the rented property, Milord. That is number one, Milord. The accused always took with her a small knife and usually inflict me and my elder sister, prior to the incident, the accused threatened us to drive us from our parental house. She often told us that she do not want us to reside in this house. The accused did not allow us to cook food and she used to pour water on the bed. Prior to the incident, I filed a case, Milord, your lordship, kindly see, filed a case against the accused for her atrocity on us. Prior to that incident, the accused poured water and urine on my body. Prior to that incident, accused physically and mentally assaulted the deceased. And when he returns from his duty, accused threw his bag. Accused also used to cut his bike. The accused usually threatened us that her brother is a police officer and no action can be taken against her. Exhibit 1 is the Adaha, so and so, and 164 statements. Now, cross-examination, if your lordship kindly see, I, along with my sister, Moina Dihinga, used to reside in the house of the deceased. At the time of incident, there was a minor daughter, aged about 4 years of age. Accused, namely Katiki Dihinga, at the time of occurrence, there was a domestic servant, Asal Panika, aged about 10 years in our house. At the time of incident, they were also present in the same house. The domestic servant was brought by the police to the police station in connection with the case. Prior to the occurrence, the accused used to quarrel with me and my elder sister. There were 6 rooms in our house and a veranda. We used to take our meal jointly with accused person. My deceased brother and accused person occupied a single room, which was used as a bedroom. Inverter was not in the bedroom of the accused, but it was in another room. It is not the fact that at the time of occurrence, accused was not present in the room where inverter was installed and I went after the incident. It is not a fact that I stated before the police, you being a nurse, you kindly see that what happened to my brother. The accused removed the plug of the inverter to commit murder. It is not a fact that I did not state before the police that before committing the murder, the accused person quarreled with my deceased brother. It is not a fact that there was a cordial relationship between the accused person and my deceased brother. I, along with my elder sister, were jealous of it and tried to separate them. There are several houses of our relative near the houses. It is not a fact. It is not a fact that after the committing the offense, the accused shouted whether my brother was died or alive. I also did not state before the police that the prior to the incident, the accused person was used to take a knife with her and intention to attack us. I filed a probate case, my lord. Your lordship, kindly see what has been FIR is that a probate case for getting the property of my deceased brother. we have not made any party to the accused in that probate case. My deceased brother, minor daughter, is still young, is still along with the accused person. I know that being the wife of being wife and daughter of the deceased, the accused and her daughter also entitled to claim share of the property. It is not a fact that I, along with my family members, threatened my deceased brother to oust me from the house, demanding our properties. My deceased brother was in service. He drew a very handsome salary. Accused person was also serving at Lahwal PHC as a nurse, and she also used to earn handsome salary. My brother, an accused person, along with their daughter, living peaceful life. It is not the fact that I, along with the other family members, interfered in the peaceful life. It is not a fact that I falsely implicated the accused person out of grudge. So that is, in Malad, is the evidence of PW1, Milad. Now, if your lordship kindly see the entire PW, now his evidence has not been shaken, or otherwise there is no doubt about that. So even in the cross-examination,
Animosity is there,
Mal-
not favorably disposed towards the accused. You did not make her party,
my lord,
despite being a wife
my,
in the probate case.
no, that's a different thing. That's
Not
No.
favorably disposed.
now, if your lordship kindly see, there's a, apart from that also, your lordship will find independent witness also. I'll come to that, my lord. One by one, I am going. Then thereafter, my lord,
But
we'll appreciate the evidence, my
there
lord.
is something, my brother and accused person along with their daughter living peaceful life.
Wait a minute.
Last but one line.
My brother and accused, well, not,
Along with their daughter
along with his
living peaceful life.
with daughter living peaceful life. Well, maybe I have to see that Assamese version also.
No, Assamese no, it is signed by additional session judge.
No, no. Oh, yes.
So there is no question of any doubt.
Right. So, this is the
And
last-
next line is, it is not a fact that I, along with my other family members, interfered in their peaceful life.
Peaceful
So this statement is correct. That is why this has come. The next line has come.
Amal. Now, next, your lordship will kindly see
It was admitted.
that now PW2, my lord. The Moni
Who is she?
she is also sister, my lord, and who,
Of the deceased.
this is, my lord, who was also
Married
present.
or unmarried?
They are unmarried.
Both are unmarried.
My lord. My lord, kindly see what she said. I know the accused person. She was married to my elder brother, you know. This is Hitendra Dihingia. I also know the complainant and deceased. My house is adjacent to
She was
the
married
deceased.
to
I'm sorry, Malak, they is adjacent to the deceased.
elder brother-in-law.
Brother-in-law, Malak.
She is not the sister.
Sister, Malak, brother, sorry, Malak. She'll be sister-in-law.
Sister.
Husband's wife. Husband's wife.
Huh?
Husband's sister. Sir.
No.
She's sister-in-law.
She was married. Right? Accused was married to my elder brother-in-law.
Then sister.
Sister.
Brother-in-law means sister's husband.
Who is brother-in-law?
They are deceased.
Right?
So she will be the sister of the accused.
Sister of the accused, Malak.
Sister of the accused.
No,
If-
no.
no.
But she
If
stays
you
separate.
see, Malak,
But she
Oh,
stays
we
separate.
need-
I know the accuser, she was married
No, this,
to my elder brother-in-law.
this witness will also will kindly say she is married. Her husband's name is Robin Dihingia. So she stays nearby. She is also one of the sister of the deceased.
I think no. She is the wife of the elder brother of the deceased.
She was married to my elder.
Younger brother of the deceased. She was married to my elder brother-in-law.
That means husband's
Husband's
brother.
right.
Husband, brother. Husband, brother.
So stays nearby, that's why.
Stays
Stays
nearby,
nearby.
I don't very much say.
Oh.
Like, ayoknase ko sa debut লাগে স্যার
সেইটোৱে একবিটা নিজে খাইছে চকটো নিজে খাইছে
আমিতো এই বেলেগৰ পৰা এই লাইটটো লাইট দিয়ে আছে ইলেক্ট্ৰিক লাইট দিব পৰা
এই পার্টটো মূল দাও তো যদি পার্টটো উলিয়াই দিয়ে হ্যাঁ remove the connection of inverter and electrocuted him with a live wire. Mr. Bora,
My lord,
we are a bit confused.
my lord.
Inverter, you
Yes.
have an inverter connection, Mr. Talukdar has inverter connection, we both have inverter connection. If the plug is put out from the plug point
My lord.
and like this, or in the stomach, they are say, is, where there will be electricity.
Well, there are two lines, my lord. One is coming from the main line and inverter, my lord.
No, the point is remove the connection of inverter.
There are, my lord, there's an inverter. One line is where from the electrical, main, electrical line comes, my lord. One is,
Because one person died in our residence, in our residence. By touching the plug, full baptism is there. So always the electrician used to say us, be careful, while taking out the plug. Full electricity.
One,
One is for charging, one is
No.
for charging.
For charging.
No, the main electricity line, that is AC we say, from the plug point, one comes
The
and
inverter.
inverter.
gets into inverter.
And one plug is put to the inverter.
Two plugs are there.
One is put to the inverter.
and that is fully electrical. Well, that the, if you.
Today I'll look into it.
Two plugs are there, two plugs are there.
And to tell others that not to touch. Okay.
Then, my lord, now what I find this Moni Dihingia is the sister of PW1 actually. You see, the PW1, so he is married and she stays nearby, my lord. Now, your lordship kindly, there's a maybe
Okay.
lordship will kindly her evidence is this. See the evidence. I know the accused person. She was married to my elder brother-in-law. He said brother-in-law. This is
Brother.
this is as a brother. This is Hitendranath. Okay. I also know the complainant and the deceased. My house is adjacent to the house of the deceased. On 25/8/2012 at about 7 o'clock morning, I was at the house of the deceased as my house was adjacent to the house of the deceased. Therefore, I frequently visited the house of the accused person, and on that day, I also went to the deceased house to bring some tea powder. Miller. I saw that the accused holding something in her hand and touched the same with the body of the deceased. Immediately, the deceased fell down on the floor. Then I went to the room. At the time, Sabitri Dihingia is also present, that is PW1, Miller. Along with the Sabitri Dihingia, lifted the deceased to the bed and saw if the deceased died or not. But the deceased could not take his breath. Then the accused went from the place of occurrence and entered her bedroom. And when I shouted her, she again came from the bedroom with that tea cup in her hand. At that time, she pretends that she do not know anything about the occurrence. The deceased died immediately after the incident. When we made hue and cry, many villages people came to the places of occurrence, and village people informed the police and took the dead body of the accused. This is at first to the Barbara PS and then to Assam Medical College, Dibrugarh, to do post-mortem examination of the deceased. About 2 years ago, prior to that incident, accused usually quarrel with the deceased person and used to obscene words. And I heard their quarrels as because our house were adjacent to her house. At that time, we tried to settle the dispute, but the accused told that she wanted all property of the deceased and therefore quarreled with the deceased person. Now, the cross-examination, Sabitri Dihingia is my elder sister. She is a sister. I did not state before the police that on that day because I went to the house of the accused to bring the tea. It is not a fact that I did not state before the police that I saw the accused holding something in her hand and touched the body of the deceased. I stayed before the police and that after hearing the hue and cry from the house of the Hitendra, I went to the house and found him lying on the floor. And I also told before the police, the accused also standing nearby the deceased. Accused person shouted to leave the deceased to the medical hospital. I did not state before the police that the accused has to pick up the quarrel.
From this
with the-
part, she said she's post occurrence.
My lord,
Post occurrence.
my lord,
From this part,
my lord.
after hearing hue and cry from the house of the.
No, no,
Hitendra,
my
I
lord,
went to his house and found him lying on the floor.
my lord, it is, no, it is, this line has been taken, my lord. It is not a fact, my lord. It has come in like that, my lord.
No,
It cannot be
it's a full stop.
after recording evidence.
My lord, it is not a fact that I did not
We
state before the
cannot-
police that I saw the accused holding the so and so. I stayed before the police that they are up to so and so, you and cry from the
Very
house.
clear, I state.
Yes, yes.
And also told before the police that the accused is also standing nearby the deceased. The accused person shouted to leave the deceased to the hospital. I did
This
not
is-
state before the police. So
This is
police-
contrary to PW1.
my lord, that's, my lord.
PW1 says, well, check whether he died or not. But here, accused said, leave the disease to medical hospital. Property, I did not state that I lifted.
Hey,
the-
please, read the screen. Read the- Now, but the accused person demanded property abstaining herself from the settlement of the matter. I did not state before the police that I lifted the deceased to the bed. It is not a fact that at the time of incident, the domestic servant of the deceased and the daughter, Srimati Maghi Dihingia, were present. It is not a fact that the till date of his deceased, Hitendra Dihingia, he was living very peaceful life with his wife. It is not a fact that as because we tried to grab the property of the deceased, we falsely implicated the accused. It is not it is not a fact that I have reposed today in favor of Savitri Dihingia. My lord, this is the evidence of the two sisters. Now, if your lordship kindly see, now this is an independent witness which has been examined as PW3, that is Devananda Kuar, my lord. Now, what he says, my lord, if your lordship kindly see page 14 of the paper book, my lord. Devananda Kuar, my lord. I know the accused person. I know both informant and deceased, Hitendra Dihingia. The incident occurred. My lord, this is very important, my lord, that he is a neighbor and they go for a morning walk, my lord. Kindly see what he says. The incident occurred on 25/8/2012 at about 7:30 AM. And on the same day, deceased died. I always went for morning walk, and on that day also I went for a morning walk, and it is my habit that I went the morning walk. I went their house. Umakanto Dihingia, elder brother of the deceased, is my close friend there. Therefore, I have a good relation with the deceased and his family. On the day of occurrence, I also went to the deceased house at about 7:30.
Where Umakanto resides? Umakanto resides where?
Is near my lord, Umakanto Dihingia. Maybe Umakanto.
He's not a
Residence-
witness.
It's not been the residence
Not
has not been stated below. I entered in the front room, which is the dining room of the deceased house, and the next room is the Hitendra's bedroom. And at that room, there was a bed. The bed where only deceased sleep alone, used by the deceased for sleeping. There was another room in front of the deceased room where the accused used to stay as a bedroom. Kindly see, they were living separately. They have a separate beds, below. In one room, she's been staying, and another room, the deceased has been staying. Though the accused and deceased are husband and wife, but they live separately at the same house. The inverter was kept on the left side of the deceased room. When I entered the deceased house, the deceased was preparing a tobacco and talking with me. My lord, your lordship, kindly see what Savitri Dihingia soul did that they are doing tobacco, my lord. Sadha. talking to me. At the same time, one Sadananda Dihingia also present with me, and the deceased casually talk with us. When we are talking with the deceased, the accused called the deceased and told me that to see the inverter which is out of order. At the material time, I was present at the house of the deceased person, and when the deceased went to see the inverter, the accused suddenly pulled the plug and touched the same with the stomach of the deceased, Milord. This is very important, Milord, by deceased, and electrocuted him with the live wire, and thereafter the accused went inside her own room and locked herself in her bedroom, Milord. That all three witnesses they say the same thing, Milord. Then we made hue and cry, neighboring people gathered. Then the accused shouted that Naimora, Naimora, and instructed us to take him to a hospital for treatment. The accused also threatened Sabiti Dihingia and told her on the next time that accused would kill Sabiti Dihingia. Someone informed police about the matter, and police came to the house of the deceased person. Police seized the inverter made so and so. Today I saw the inverter along with the connection switchboard, leak plug, and at the time of incident was electricity flowing in the plug. Live wire, we do not allow anybody to touch the plug. After arrival of the police, the wire was also deactivated. Material exhibit 10, the inverter. Material exhibit 2 is the switchboard and lead plug. This witness gave a demo how the live wire and block was unplugged and touched with the body of the deceased to get electrocuted. Police took my statement in connection with the case, and I stated the same before the police as I stated in the court today. Now, it's very important so far the evidence of PW3 is concerned, Milord. Now, what the cross says, Milord, in the cross. There is a Maruti car in the house of the deceased. It is not true that after the death of the deceased, I used to drive the car to the deceased. It is not a fact that while I was driving the car, the deceased, on the seeing of the accused person stopped my car and asked to hand over the vehicle to her. It is true that Borbua police station called me to the police station in connection with the car of the deceased. I appeared in the Borbua police station. No case has been registered against me in Borbua police station. It is a fact that the police of Borbua police were searching me and called me over phone, but I have not appeared in the Borbua police stations till now. I know that the case has been going to be registered against me relating to the vehicle which is claimed by the accused person. It is not a fact that the order to grab the vehicle, the deceased, I gave false evidence against the accused person. It is not a fact that I stated before the police that often I go to the morning walk. I visited the house of deceased, and on the day of occurrence, I visited the house of the deceased, and I found deceased was preparing tobacco, and accused called him and told him to see the inverter which is out of order, or suddenly the accused unplugged the wire of the inverted and touched it in the stomach of the deceased and electrocuted him. Immediately thereafter, the accused went inside the room and locked herself in the room. At the time of occurrence, there was a maid girl in the house of the deceased. At the time of occurrence, the daughter of the deceased and the accused person was also present in the house. It is not a fact that the accused and deceased, along with their children, used to reside in the same house. Separately for the two unmarried sisters of the deceased, it is not a fact that as the informant allured me to give the car to me if I depose in the paper, it is not a fact the deceased and the accused person lived together happily and peacefully, and on being induced by the deceased to unmarried sister, I conspired to evict them from the house of the deceased for my wrongful gain. Now, there's another Sadananda Dihingia Miller. That is PW4 Miller. He is also an eyewitness, Miller. Sadananda Dihingia. May I read, Miller?
Yes.
I know the accused person. I know both informant and the deceased. My lord, due to that, so for the PW3 is concerned, my lord, your lordship, it's absolutely on her. In his evidence is established that he has been put to death by electrocuting by putting the plug in the stomach, my lord. My house is situated near the house of the accused person at the distance of 2 houses. On the day of occurrence, in the morning, standing on the road near the culvert, from the other side of the Devananda Court came from morning walk, my lord, the PW3, my lord, Devananda Court, and stayed for some minutes near us. The deceased Hitendra Dihingia also went with me in that morning for grazing our cattle, and he also standing with me on the road. After some time, this is Hitendra Dihingia invited me and Devananda Kaur to his house for morning tea. After some time, Dipankar Dihingia also came to the house of the deceased. At first, in the front room, the drawing room, and at the first, we arrived at the drawing room. The next room is bedroom, and one inverter was kept beside the table of the bedroom. The room where the inverter was kept was used as a guest room, and sometimes deceased also used the room. We all went to the guest room, public bedroom. The deceased opened the drawer and took some tobacco. Suddenly, Dipanjali came from her bedroom and her room, and situated adjacent to the guest room, removed the plug of the inverter of the switchboard and touched it on the stomach of the deceased. The deceased shouted and fell down on the floor. He made hue and cry. We lifted the deceased on the bed. After some time, he died. We made hue and cry, and near the police gathered. People informed the police, and police came to the house of the deceased person. The accused is the wife of the deceased Hitendra. When police came to the house of the deceased, I was present at that point of time. Police seized the inverter and took the signature of the seizure list. Exhibit 3 is the seizure list, and Exhibit 3.3 is my signature. Today, I see one inverter which was seized by the police from the house of the accused person. Material Exhibit 1 is the inverter. Police took my statement. I stated the same before the police as a report in the court today. Now, the cross-examination, it is not a fact that I have not seen the occurrence. It is also not a fact that I was not present at the house of deceased. I am a cultivator and I have 8 bighas of cultivable land. It is not a fact that no person of the village go for a morning walk. It is not a fact that I did not state before the police that I was going for morning walk, and on the day I met Devananda Kaur and Dipankar Dihingia. It is not a fact that I did not state before the police that the deceased met me along with the Devananda Kaur and Dipankar Dihingia, invited us to his house for a cup of tea. It is not a fact that I am only the seizure witnesses of this case, and I am not the eyewitness. Once the accused person, with the assistance of the police, went to her matrimonial house to recover her street hunts, she recovered almost all the articles in my presence, and I put the signature on the list prepared by the police. It is not a fact that I interfered, taking back the street hunt by the accused, as I had vested interest. Today, I came to the court along with the Savitri Dihingia yesterday. Also, I came along with her to adduce evidence in the connection with this case. On previous days, I also came with that, adduced my evidence along with the Savitri Dihingia. It is not a fact that I adduced evidence as tutored by Savitri Dihingia. That is PW1, my lord. That is also, my lord, he is also eyewitness. He is also eyewitness, my lord, to the occurrence, and his evidence is also not shaken, my lord. Now, 5, my lord, if your lordship can list 5. 5, your lordship also find Dipankar Dihingia, my lord, who was also present, my lord. That's one. He is also eyewitness, my lord. Now, what he says, my lord, his evidence. I know the accused person. I also know the informant as well as the deceased Hitendra Dihingia. Deceased Hitendra Dihingia was our neighbor. The incident occurred on 25/8/2012. On the day of occurrence, I was sitting with Hitendra Dihingia on my bench on the outside the veranda of the deceased house. My uncle deceased Hitendra Dihingia went inside to bring tobacco. Veranda and the room where deceased went to bring tobacco is adjacent to each other. From the veranda, the room can be saw. I saw from the veranda, the accused Dipanjali Dihingia came inside from her room and suddenly she pulled plug of the inverter and touched it in the stomach of the deceased, my lord. This, my lord, these sentences, my lord, has been said by everyone. There's now no, my lord, any sort of contradictions so far these statements are concerned. 1, 2, 3, 4, 5 say the same thing, the incident, my lord. Immediately, the deceased fell down on the floor. At that time, the sister of the Hitendra Dihingia, Mani Dihingia, Satyendra Dihingia tried to leave the deceased on the bed of the Dipanjali Dihingia, immediately went inside her bedroom and shouted to take hospital to the deceased. The deceased Hitendra Naika immediately died after the incident. The family members of the deceased and other present made hue and cry. The village people gathered at the house of the accused, deceased person. Police took my statement and I stated same before the police as I stated in the court today. Police took my signature in the inquest, exhibit for the inquest. For my signature today, I see the material exhibit 1 inverter, that is the inverter by which the accused connected the plug to the deceased. It is not a fact that I have not seen the occurrence. It is not a fact that I stated before the police that after the hearing hue and cry from the house of the accused person, I came to the house and found that the deceased was lying on the ground. It is also not a fact that I stated before the police that when I asked the accused person about the incident, then she replied that the deceased was electrocuted while cleaning the inverters. It is also not fact that I have stated before the police that I do not know the cause of the death of the deceased and I have not seen the occurrence. There is a car of the accused person which was purchased by the deceased. The informant is my aunt. It is not a fact. I do not know anything about the occurrence. It is also not a fact that today I deposed as tutored by the aunt. I do not know whether the accused person brought the plug from the switchboard or not. Now, there's another, my lord, Paranjyoti Dihingia, my lord. He is also eyewitness, PW6, my lord. She is also an independent witness, my lord. He is also. What he says, my lord, I know the accused person, I know the accused. She is my co-villagers. I also know the informant, Savitri Dihingia. I know that this is Hitendra Dihingia. He was also husband of the accused person. This is Hitendra Dihingia, died in the year 2012. On the day of occurrence at about 7 a.m., I went to the house of the deceased person and I saw Hitendra Dihingia was sitting in a chair by the side of the door and he was preparing a tobacco on his palm. Then I saw that the accused Gitanjali Dihingia came, my lord, very important, my lord. These are the facts, actual fact which has been coming to the evidence, my lord, which has been discarded by, my lord, trial court, my lord. Then I saw the accused Gitanjali Dihingia came from inside the house and rebuked the accused person, and all of a sudden she took out the live wire from the inverter, which was kept by the side of the door where the deceased was sitting, and touched the wire in the stomach of the deceased person, as a result of which Hitendra Dihingia fell down from the chair. Then the Hitendra Dihingia shouted. Then hearing the shout, Hitendra Dihingia and two sisters, Savitri Dihingia and Moina Dihingia, who were inside the house, came running to the front room where the incident occurred. Another two persons, Devananda Kaur and Sadananda, were also present inside the house, who has come running to the entrance of the house where the incident took place. Then I, along with her other family member, lifted the Hitendra Dihingia from the ground, it should be from the ground, and made him lie down on the bed, and then he died. Villagers also gathered there. I also know that the often quarrel took place between. Well, this is also very important. There's two factors also fact that often quarrel took place between the accused and the deceased person. After around half an hour, police arrived there, and police recorded my statement. Police conducted the inquest over that dead body. Exhibit 4 is the inquest report. 4.2 is my signature. Inquest report. I had also gone with the deceased of the Assam to the Assam Medical College Hospital, Dibrugarh, when the dead body was taken for post-mortem of examinations. Now, the cross, my lord. It is not true that I came to the place of occurrence after the incident. It is not true that I was at my house at the time of occurrence. It is not a fact that my house is about half a kilometer away from the place of occurrence. I did not state before the place that today so and so I was at my house. After hearing halla, I rushed to the house of deceased and he was found lying on a bed. Then the elder sister, deceased, informed me that the deceased died due to the electrocution. I did not state before the police that I do not know about the incident and I did not see the occurrence. It is not a fact that I only took my signature on the inquest report and I do not know anything about the occurrence. I did not state before the police that on the day of occurrence, I went to the house of the deceased and found him sitting inside the corner. I also met the Devananda Kaur and Sadananda Dihinga at his house. It is not a fact that because I am adducing false evidence today, that is why I did not say like this before police. Sabiti Dihinga and Moina Dihinga are unmarried sisters of the deceased, Hitendra Dihinga. They were living together along with an accused person, the deceased Hitendra Dihinga. I know that there was a domestic servant of the deceased at the time of occurrence, and there was also a female child of the accused person, which is about 1.5 years at the time of occurrence. I do not know the name of the domestic servant and the name of the female child, the accused. The age of the domestic servant was about 12 years. I know that the domestic servant was taken by Borbora police station immediately after the occurrence. I do not know whether Devananda Kaur is driving a vehicle of the accused person. Today I met Sabiti Dihinga and Uma Dihinga. It is not a fact that I have given my evidence as treated by Sabiti Dihinga and Uma Dihinga. Accused person is not a co-blazer of Shweta, but she is married in our village. It is not a fact I have deposed for. Now, PW7 Miller. He is a Dr. Subhrajyoti Deka, Dr. Miller, who did the postmortem Miller, performed the postmortem Miller. Now, injuries Miller, if your lordship kindly see, there are only one injury Miller. The trial court has based the postmortem report on. He said that there should be a wound in the stomach. Why on the hand Miller? That what is. Now, if you see the wound, it has been described. External appearance, kindly see, on average male body wearing one underwear, long pant, Genji shirt, body warm touch, eyes closed, mouth closed, so and so. All over body, postmortem staining faintly present on the back except on the pressure areas. Now injuries, this is important. Electric entry wounds, this is very electric entry wounds of 1.5 cm into 0.8 cm over the left finger in the ventral aspect, mid of the third finger and vertically placed base of the pale ridge in surrounding and are hard fluttering of the skin detected. No ligatures mark detected. On dissection, neck tissue found healthy. Others are not relevant to this. I have skipped this one. Opinion, Milord. You lordship kindly see what the death is due to syncope as result of ventricular fibrillations. Well, I do not know what is meaning. Consequent and antemortem electrocutions. Time since 4 to 6 years. The result is electrocutions. The opinion, the cause of death. And the cross also is doubly verified. In the cross, the question has been asked to the doctor whether he died, how he died. It says from the examination, it appears that the person died due to electrocution. So electrocution is not disputed. So for the electrocution is concerned, the body of the deceased is concerned. Medical also proved. Everything has been proved. Now 8 is the IO, Milan. And what IO say on 25/8, because IO came later on, Milan, came later on. after 10-15 minutes of the occurrence. On 25/8/2012, I was walking as a SI of Barbara Police Station on the day. At about 8:10 a.m., one telephonic information was received by Sri OC Devajit Datta that about the death of a Hiranyaka by electric shock. And OC entered into the general diary of Barbara Police Station and endorsed me to the investigation in the case. I immediately proceeded to the place of occurrence at Ranigaon under the Barbara Police Station. I went to the house of the deceased Hitendra Ding and found the dead body on the bed. I made the inquest over the dead body in presence of the executive magistrate. I also drew a sketch map of the place of occurrence and recorded the statements of the witnesses and the place of occurrence. I also sent the dead body to the Assam Medical College, Dibrugarh, for which the post-mortem, after recording the statement of the witnesses, I found sufficient materials against the accused person that she was killed, her husband, by electrocutions. Thereafter, I returned to the police station, and on the same day, informant Sabitri Dihingya lodged an Edaher in connection with the case after receiving the Edaher so-and-so. Barbara says that the case being Barbara police case number so-and-so. After receiving the Edaher, I went to the deceased house and interrogated the name of the accused, and after finding sufficient materials, I arrested the accused Dipanjali Khanikar, and on the same date, I sent her to the Honorable Court. On 31/8/2000, I went to the house of the informant and recorded her statement. I also sent the Honorable Court for recording her statement under section 164 164 CRPC. On 11/9/2012, I again went to the house of the deceased, seized the inverter along with the connection switchboard and presence of the witness. I also recorded the statement of the seizure witnesses. Today, I see the inverter along with the connection of the switchboard, which was seized by me. Material Exhibit 1 is the inverter. Material Exhibit 2 is the connection switchboard. I collected the post-mortem report, the victim, and also 164 statement of the informant. I completed the investigation of the case and submitted a charge sheet against the accused person under section 302 IPC. Exhibit 1 is the Edaher. Exhibit 2 is the signature of the OC Devajit Datta, which I know. Exhibit 5 is the extract of the GD entry. 5.1 is the signature of the OC Devajit, which I know. Exhibit C is the sketch map, which was drawn by me. In Exhibit 6.1 is my signatures. Exhibit 7 is the charge sheet, and 7.1 is my signature. Now, it appears the Edaher, the cross-examination, that the occurrence took place on 25/8/2012. Seizure was made on 11/9/2012. I have not explained the cause of delay for the seizure. During the seizure, 3 persons were made as a witness. One of them is the informant Hassan. I have shown 2 persons, Devananda and Sadananda Dihingya, as a seizure witness. During the investigations, Sabitri Dihingya stated that she asked the accused to see her brother as the accused was a nurse. PW1 did not state before me during the investigation that prior to the incident, accused used to carry a knife, intending to attack them. During the investigation, I did not examine any girl, namely Aluk Asol Panika, aged about 10 years. PW2 Pani Dihingya did money, it should be Pani, written like Pani, did not state that on the day of occurrence, he went to the house of the accused to bring tea. This witness also did not state before me that she saw the accused was holding the something in her hand and touched the same with her body of the deceased. PW3, Devananda Kaur, is a seizure witness. He also stated before me that he often he also did not state before me that he often go for morning walk and visit the house of the deceased. He also did not state that on the day of occurrence, he visited the house of the deceased and found that he was preparing tobacco, and accused called him to see the inverter, which was out of order. Suddenly, the accused unplugged the wire and inverter and touched the stomach of the victim and electrocuted him. PW4, Sadananda Dihingya did not state before me that he went for morning walk. He met Devananda Kaur and Dipankar Dihingya. He also did not state before me that this is met along with Devananda Kaur and Dipankar Dihingya, and he invited him to the house of cup of tea. In my sketch map, I have not specifically stated about the occupants of the rooms. I have not examined Upen Dihingia and Dilip Borwa as a witness in the case, although I mentioned the name in my sketch. The witness whom I examined, all of them were relative of the imprisoned. It is not a fact that I did not investigate it into the case properly. So these are the evidences, my lord. Now there's a 164 statement also which has been recorded by my lord. Well, that can be used for corroboration and contradictions, my lord. 164 statement, my lord. If your lordship kindly see that 164 statement is at page, my lord, 47, my lord, of the paper book, my lord. My age and addresses mentioned above are true. I stay with my elder sister Moina Dihingia and sister-in-law so my younger brother deceased Hitendra Dihingia used to stay with us. Me too. My elder sister and I were unmarried. My sister-in-law Dipanjali was disliked my elder sister and me. My sister-in-law also used to quarrel with my younger brother. In the morning, 21st, when my younger brother was preparing a tobacco, this is same thing has been sent by 1, 2, 3, 4, 5. Tobacco. My sister-in-law unplugged the plug of the inverter and making the touch of the right side of the abdomen of my younger brother. She left that places. My younger brother immediately fell down by making ear piercing strain. Then I shouted, I can see that you are being killed. My sister-in-law threatened me to keep mum or else she would cut me. Thereafter, my younger brother died on the spot instantly. I myself witnessed the younger brother being killed by my sister-in-law by means of electric shock at that time I was in the adjacent group itself. That much I have to say only, my lord. This is the 164 statement. My lord, now there is also, my lord, defense evidence also there. CS reduced evidence, my lord. That is at page Dipanjali Dihingia, the accused, my lord, 32, page 32, my lord. What's he stated, my lord? Can you see? I was in a separate room at the time of death of my husband. There were 6 rooms in our house. My husband and I used to use 2 rooms. Inverter was not in the room in which we two used to stay. I could not able to go to the room in which the inverter was as per my wish, and also elder sister did not allow me to enter there, my lord. So these are the things has not been come in the cross the evidence, my lord. No suggestion to add to this. For the first time, she reduced this in an evidence, my lord, which cannot be taken in the face value, my lord, as there is no suggestion to this effect also in the evidence, my lord. At the time of incident, I was making a tea in the kitchen of my room. My husband, elder sister called me and asked me to see my husband. I'm a nurse by profession. I saw my husband lying. The wife of my husband, brother, and 2 elder sisters, my husband, Moina, Sabiti, Parul, Nina, Dinga were there. My daughter was sleeping in my room. My lord, these are things, my lord, what she stated, my lord. Who are the present, my lord? This is very important. Why I'm saying, my lord, the trial court has said that except she has not stated that who are a person present at that time. So that is why he disbelieved, my lord. My room and the maid was there, my lord. The name of my daughter was Britika, and the name of the maid is Achal Palika. Police interrogated Achal Palika, the elder sister of my husband, disliked me from the time of our marriage since they were not married. And they asked my husband to transfer the lands in their name in writing, but my husband did not agree to do so. They asked me to leave the house, but I stayed there by arriving at a mutual understanding. But their torture on me got increased. I had harmonious relation with my husband and had no quarrel between us. What we said, harmonious relations, and they stayed separately, my lord. All have stated they are stating, even C also stated, my lord. After the death of my husband, he filed a probate case with regard to the properties of my husband, but I was not made a party. That is afterward. That is nothing related with this things, my lord. She want to bring that, we had an enmity with her, my lord. Party, my lord. From my engaged advocate, and when I appeared in the court, my husband, elder brother, withdraw the said case. The allegation leveled against me is false, so and so. The certified copy of order through her the probate case is withdrawn. Cross, my lord. My husband died at 7:30, so and so. Were there in the first floor, a bed, there is the next room, and my husband occasionally used to stay in that room. The room facing the room, my bedroom, the inverter was in the room in which the bed was there. I do not know whether Savitri Dhingia lost any case under DV Act against me before the death of my husband. I do not know whether my husband lost any divorce case me before so and so. Because I have specifically asked these questions, my lord. He said that I do not have any knowledge. My lord, that is why the FIR, which I mentioned, my lord, these are reflection in the cross-examination in the DW, my lord. I do not know whether Savitri Dhingia lost any complaint against me with Sodar Police Station on 22/8/2020. It is not a fact that I had been torturing the elder sister of my husband for a long time and that I killed my husband by putting so and so. There's a specific, my lord, on the last line of this evidence, there's a specific suggestion to that. You have tortured my brother and my lord, and for a long time, and I have killed her. There's a specific suggestion to that, which my lord corroborated with the evidence of PDL 1, 2, 3, 4, 5, particularly that part, my lord. No, suggestion can be used. Why suggestion is being used? Suppose, my lord, so far as defense evidence is concerned, if there is nothing, no suggestion, if no plea has been taken, what is the value of the defense witnesses? For the first time he is taking, my lord, that is the value of the suggestion only. Why suggestion has been put? Suggestion is not for putting for fun, my lord. Suggestion has been put that I have taken, whether I have taken a plea or not, my lord. That is the value of the suggestion. We are not making this for a fun, suggestion making for fun. Now, 313 also, my lord, so you see, flat denial, nothing. Now, the ground on which, my lord, the acquittal was made, my lord, very kindly see, the trial court, with all respect, has explained everything. Now come to paragraph 12. What is stated? He has discarded PW, fine. PW 1 and 2, fine, I agree, they are a relative. So for the PW 2, 3, my lord, your lordship wants that quality of evidence, not quantity, my lord. Even if it is one, my lord. Lordship, kindly see paragraph 12. Now, paragraph 12 is the finding of the trial court, my lord. Now, I'll just read slowly the findings, my lord. Now, what it stated, my lord.
Yes.
As already stated, it is alleged that the accused had murdered her husband by electrocuting. In their evidence, the witness also deposed, implicating the accused. But the question is how far they can be relied upon to hold the accused guilty for alleged offense. In search of answer to this, I have very carefully scrutinized the materials before me. In the case, death of Sitendra Hagia, the husband of the accused, neither denied or disputed. We agreed, my lord, 100%, my lord. During their evidence, the witnesses said the accused removed the plug of the inverter and brought it in contact with the Hitendra for which he died. It appears from the evidence, the witness that all of them has witnessed witnessed the occurrence, but from the evidence of PW1, my lord, the informant submitted here, it appears that at the time of occurrence, there was none. She did not specifically state that except herself, anyone else had witnessed the occurrence. That is not, no, my lord, what is stated, my lord. And but from the evidence of Moni Dihingya, it appears that the occurrence took place in her presence. Moni Dihingya also stated that she, along with the Sabitri Dihingya, took Hitendra to the bed, but Sabitri remained silent about it during her evidence. At the same time, Moni Dihingya admitted during the cross-examination that she has stated during the investigation that hearing hue and cry, she came to the house of the accused. The informant Sabitri Dihingya and Moni Dihingya remained silent about the Devananda Court PW3, so-and-so, 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 and Pranabjyoti Dihingya at the PWC. But the evidence Devananda Kaur, Sadananda Dihingya, Dipankar Dihingya, and Paranjyoti Dihingya revealed that they were also present at the time of alleged occurrence. Sadananda Dihingya and Devabrata Kaur narrated about their presence at the time of occurrence, but they remained silent about the Paranjyoti Dihingya. But the evidence of the Paranjyoti evidence that he was also present at the time of relevant time. The witnesses stated that the accused removed the plug and of the inverter and brought in the contact of the stomach of the deceased. But the evidence of the doctor do not disclose that the deceased was sustained injury in his stomach. It appears that the evidence doctor there was an electric entry wood owned of 1.5 into 8 cm over left middle finger of the ventral aspect. Meet so-and-so, so it is my considered opinion that had the deceased sustained injury in the stomach, the doctor would have detected the same at the time of autopsy, but the doctor did not find any injury on the stomach of the deceased. From the evidence given in the court, Sadananda Dihingya, it appears that after the occurrence, police arrived at seized inverter, so-and-so, so-and-so. That inverter was seized on so-and-so. At occurrence allegedly took place on 25/8/2000. It appears from the evidence of the witnesses made improvement at the time of deposing before the court during data. As such, this above discussion, the factor do not find enemy link in favor of the prosecution and hold accused guilty of the alleged offense. As such, in Kolkata, I hold the prosecution failed to establish the guilt of the accused beyond all reasonable doubt, and for that he is acquitted of the charge 302 million. Now, what the trial court says, number one, that Sabitri Dihingya, Moni Dihingya did not stay at that point of time. They were these persons. He has completely discarded the evidence of 3, 4, 5, 6. And also doctor, they said, now suppose if a plug has been in, definitely a normal person, what will you do? He will just automatically he'll put his hand in there to the wire. So normally if something, even if, my lord, if something is in the body, definitely the person, whether it is right or left, he will, what the action of the person will be doing. So definitely his hand will go first. So my respectful submission, my lord, the learned trial court has completely erred, my lord, while discussing appreciating the evidence on record, my lord. It's a clear case of a conviction, my lord, by which, my lord, 1, 2, 3, 4, my lord, even leaving behind, my lord, 1, 2, my lord, your lordship, how can you disbelieve this evidence of 3, 4, 5, 6, my lord? You have to show at least something, my lord, contradictions. That these are the contradictions for which this evidence could not be believed, my lord. So definitely, my lord, it has to be it is a duty of the prosecution to prove, my lord, beyond all reasonable. If there is a doubt, my lord, definitely, if there is even 1%, 2%, 10% doubt also, definitely it goes in favor of the accused. Now, where is the doubt here, my lord? My respectful submission, my lord, the trial court has completely failed to consider its, my lord, evidence, my lord, appreciated its evidence over the 1, 2, 3, 4, 5, and 6 is concerned. Comes to an erroneous findings, my lord, and which is that also taking the evidence of medical evidence, my lord. Now, that is my submission before this honorable court, my lord. It's a clear case where, my lord, under 372, my lord, is a case of a conviction, my lord, that cannot be, my lord, this appeal has to be allowed, my lord. subject to my, what my learned friend says, my lord, I'll get a rate of reply.
White they could say.
Everybody has his group of Yes, sir. No. No, really.
So what is the principle in case of appeal against acquittal?
My lord, if it is, if it has to be convict, my lord, appeal, if the appeal has to be allowed, my lord, then the punishment has to be,
What is the standard?
standard is that whether, standard is that whether, number one, if your lordship find that it's an illegal and wrong judgment, your lordship has to be set, it's not a revision to send it back again, my lord. It has to be, my lord, to be set aside and quashed and has to be, my lord, punished. And that, if it is, suppose if it is not in the 302 or 304, it's up to the court, my lord. And so far, my lord, even if, my lord, the defense evidence will be taken at par, when, my lord, then if it is, my lord, if the state, what she stated, my lord, if she has taken it, these things plea in the evidence, my lord, how the plea has to be taken by way of a suggestion, my lord, nothing is short of a word, my lord. No word has been mentioned and says come for the first time that these are these so and so, so and so. So, so defense evidence doesn't have any value, carry a value. Had it been taken, this definitely, yes, then there will be a value so far the defense evidence is concerned.
Yes.
Yeah, please, Your Lordship. So far, the other witnesses are concerned, eyewitnesses. Nowhere it is stated in the affair that those persons were present at the time, relevant point of time. This is most important. Only Savitri Dihania, as per the evidence of PW1, she only witnessed the occurrence. So the other witnesses, they have been cooked up later on. Because nowhere she has stated in her evidence that so and so were also present at the time of occurrence. So everybody wants to be a
There are so many eyewitness bundle of.
bundle. They want to claim, everybody claims themselves to be eyewitness. Even the PW6, he doesn't say about the other two witnesses, PW4 and 5. He says as if they were sitting in another room. And he is the only person who has witnessed the occurrence, not even Savitri. So for PW6 is concerned. So
Have you gone through the cross-examination of PW5 and PW6?
5, Lordship. And moreover, all the witnesses, they are related witness. Even the IO has stated, they are all family members. So they stay nearby. The PW5 you are also saying. So for PW5 is concerned, it is not a-
Three, 4, they are not related witness otherwise.
No, T4 is not related, even 5.
But the IO has stated. IO has stated in cross.
But
All the witnesses are.
they are not related. You have not brought that thing into record that
It has not come in
PW3
record.
or 4,
And
they
so
are
far-
related
Lordship.
and they are in a status
IO's
of.
evidence your Lordship will kindly see. So for 3 is concerned, contradiction is there. He has not stated.
Huh?
Regarding PW3, page 30, your Lordship will kindly come.
Is 30.
IO, PW8. Contradictions have been proved.
Hmm?
Devananda, last para. PW Devananda Kumar is a Caesar witness. He did not state before me that he often go on for morning walk and visit the house of the deceased. He also did not state on the date of occurrence he visited the house of the deceased and found that he was preparing tobacco, and the accused called him and told to see the inverter, which was out of order. Suddenly, the accused unplugged the wire of the inverter, touched the stomach of the victim and left it with him. So that part was never stated before IO.
Whether this is the way to bring contradiction.
But he has admitted that
Who?
PW8, the IO has admitted that PW3 has not stated before him at the time of 161 statement regarding this thing.
But is this the manner omission is to be?
But your Lordship will kindly see in cross also that was put to PW3.
You had all the opportunity during cross.
The cross opportunity was used. He has admitted, IO has admitted, yes, he has not,
No,
PW3 did not state before. me
omission
that
or
this-
contradiction, whatever. Is this the manner to
A
bring?
manner is.
Huh?
But IO has stated, yes, he did not state before me. In his statement under 161 regarding this thing. Regarding that he went there for morning walk, he went there for a cup of tea, then the incident occurred. Those things were not stated. That has come, clearly come. Then PW4, Sadananda Dihinga did not state before we went for morning walk. He again did not state regarding Devananda Kaur and Dipankar Dihinga. And in 378, Lordship will kindly see 372 or 378, whether there is perversity in the judgment, whether the finding is perverse. So the Lanet trial court, based on the evidence on record, has passed a finding, has come to a finding that they are not reliable witness, Lordship.
So when suggestions were put to the prosecution witnesses, they denied. Then whether that confirmation by
IO has confirmed.
IO will
So far,
suffice.
PW3 and 4, it has been
Will
confirmed.
suffice.
Then PW2 has.
No, will
Also stated.
suffice.
And another thing regarding the injury part that the trial court has because everybody has stated that it was thrown into the stomach. And injury was found in the hand. So there is, the corroboration is not there, so for the injury is also concerned. So everybody's statement is the stomach, and one witness doesn't say about the other, that he was also present. So there is a doubt with regard to the incident. Of course, admitted fact is he died due to electrocution, that is, we cannot deny that. But whether it was done by Deepanjali, that is to be looked into.
Decided not to be executed. I was thinking, I will compare to the same. Admitted animosity. Baki.
And regarding the seizure also, it was seized on 11/9, the inverter and the occurrence took place on 25/8/12, it was seized on 11/9, after about 15 days.
What kind of defect? Inverter was not working. Then whether it had electricity?
That has not been established by the, it is the
No,
Bangalore.
Mr. Bora,
My lord,
inverter itself was not working.
hello,
Whether it had electricity?
Out of order, it was stated.
my lord, no, at that point of time, my lord, what has happened, if you lordship can see, they have, the evidence shows, say that there is a warning not to touch this one, then they have to switch off that
This,
one.
all these witnesses
The matter of.
were categorical in their testimony that that plug was unplugged plug which had electricity was touched in the stomach. That whether it works like that, yate mailo tipa, gorgam palego hipa.
My
Because
lord,
plug
no,
when
no,
it is removed,
He's-
it will automatically go.
my lord, no.
His fingers were burned.
My lord, yes, my lord, there is a
Additional-
plug.
Fingers were burned,
No, no,
and there is nothing in the let us see stomach. PM report.
PM
I have
report,
marked.
PW7.
PM report. PM report.
PM report.
I have marked.
There's nothing. PM report is page
Let us see
57.
stomach,
Page 57.
my lord.
abdomen,
Abdomen is healthy.
abdomen.
Yes, my lord, there's only one injury, my lord, that is on a hand, my lord.
Or that to fingers.
My lord,
That
your
two
lordship-
fingers.
My lord, your lordship has to be, has to see that it is. not-
So whether these witnesses can be categorized as wholly reliable witness
My
That,
lord,
that is the point.
and wholly unreliable, partly reliable or partly unreliable.
Another
If
thing I
it is
want to-
partly reliable, partly unreliable, then double presumption already working in favor of the accused
accused definitely.
may
I have
prevail.
Prevail, my lord.
So
That-
everybody was categorical, stomach.
Stone. Even
How
64 statement.
this page 59
Basically.
and 60 paper book,
My lord,
60
60
walls were
stomach
heavy,
and it counted
abdomen,
healthy,
walls
active.
were healthy,
Healthy,
nothing.
nothing is there.
definitely there will be nothing because
Nothing.
there cannot be a bruise on it, my lord. There cannot be a wound, my lord. This is an electrical.
Stomach, full electric,
Malak-
stomach,
Some
we,
burn-
let us
burn portion
admit,
must be there.
My lord,
heavy
burn-
power,
burn-
as MS Begum has said, heavy power touched a live wire on the stomach.
At least burn injury will be there.
my lord will, I'll just clarify.
And we have read 161.
Yes, yes. We, my lord.
Another
To
thing
be.
Another thing I want to point out, that GD entry was there. 56 year will kindly say initially. Somebody has informed. Now someone informs the police station over phone that a man by name Hiteno Dinga has died due to electric shock inside his house.
The second is
Yes.
receipt of this
Ah.
telephonic information. GD entry.
Who informed?
Someone informed, someone from the village most probably informed. It has been noted, GD entry is there, page 56. Someone informed the police station over phone that a man by name of Hitendra Dihingia has died due to electric shock inside his house. So he's died of electric shock. It was not stated that somebody has put the wire.
Yes, MS Begum.
Also, the fact cannot be denied that he was electrical, is died. And all the witnesses, Lord, they have seen that something had happened from the inverter, that also the accused have unplugged. Actually. Unplug and throw in the stomach, then Lordship, he may touch for safety. Once anything is thrown, Lordship, immediately hand comes, Lordship. When somebody throws,
But touched.
touch, Lordship.
Now let us see touched. Let us
Touched.
see all 3-4 witnesses say touched. The stomach. Let us see the word, exact word.
Lordship. PW,
At least PW 3, 4, 5, all those so-called independent witnesses. So-called independent witnesses.
All touched.
So,
took the
the
plug and
accused-
touch the same in the stomach.
Stomach. Then next.
PW,
So
Lordship.
PW3 is clear. That's the same in the stomach. But the walls of stomach is absolutely plain.
Page 20, PW.
We are 17 then. This PW,
20,
four.
Page 20.
oh no, 17. Suddenly the accused unplugged the wife of the inverter and touched it in the stomach of the deceased. Electrocuted him.
Electrocuted.
Nobody said that his hand came in the middle to intervene. Nobody said. They were so close, lifting the accused to the bed, but nobody said.
for safety.
Then page 20, on the stomach of the deceased. The deceased shouted and fell down on the floor. They were hardly 1-2 meter distance from the deceased and the accused, as they have testified.
Page 22.
Then
Page 22.
touched it in the stomach of the deceased. Immediately the deceased fell down on the floor.
Page 25 also.
25. Touched the wire in the stomach. Fell down. Nobody said.
these
So close.
this has been stated,
So far, 1 and 2, they are not favorably disposed towards the accused. That has come on record.
my lord, that's a me, but so far the 3, 4, 5, Lordship can you see? The fact of the matter is this, number one, the date is number this, number
He
two,
has also some,
my lord, 3, 4, 5, 6, my lord.
3 is also doubtful
3, 4, 5, 6.
because of the car.
No, that's a different thing, my lord. Yeah, which is, my lord, which, my lord, has to be, my lord, defense has to be brought in. That is nothing, my lord. That cannot be a related so and so because of the car he adduced falsely. That's not the fact, my lord. The fact remains that number one, date is not disputed. The date caused due to the electrifications. Now, the question is who has, my lord, whether it is as a result of the electrification done by the accused or not. That is the question before the court only to decide, my lord.
Whether he have himself not plugged the.
Now, only thing is this,
Deceased have not himself plugged the inverter. point.
that the common
is
people,
there.
that the people, my lord, what is stated, my lord, that normally when a plug has been pulled up and put there only, my lord, what normally do, my lord? Even when something, even an insect also come, my lord, it first, the hand comes, my lord. When he touched this, immediately it had, there's a mark 1.5 and so, that is on the in the hand only. It's not that the only, because when you have brought in this thing, he immediately put, that is a common thing, my lord. Even see, kindly see, even in an insect or anything comes on the body, first where? First the hand
We
goes.
don't know if, MS Begum says that heavy electricity.
No, there are
Once
heavy
it is heavy
electricity is what?
electricity fell,
No,
then
it-
fell
it-
down.
This is, my lord, is a, my lord,
Not
there are
even
two-
burn
no, no,
injury.
there's two different things, my lord. One is DC and one is AC, my lord.
Oh,
Alternative current, my lord. And direct current, my lord. Heavy is what?
we
230
have to
volt.
call an electric
No, no,
expert. then.
230 voltage, my lord. Nothing
We
more
have to call an
220,
electric
not more
expert.
than that, my lord. Now, it's not.
We'll call the chairman of the ACB.
My lord will, my lord,
Okay.
my lord, just another things I want to clarify. It's not a weapons or any instrument that where if you put it, it be there. It's a wire, my lord, flexible, my lord. When it is been brought, my lord, it plug is there. Plug always be hanging with a wire only. So it cannot be, my lord, stick in one place, my lord.
Immediately.
So
first
immediately, my lord, what has happened? When this has been pulled up, my lord, bringing to a body, near to the body, then the reaction of the person who was there, my lord, definitely he will, what they do? He will definitely put hand on it, my lord. That is why the electrocution was on the hand, the mark was on the hand only. It was not, it cannot be, my lord. That cannot, the plug cannot enter in the stomach, my lord. It cannot be placed in one places only. It will fall, immediately it will fall.
Then he grabbed.
Oh, yes,
first
that is the thing. The plug cannot, it's not a, there cannot be in the stomach, there cannot be a plug point, my lord. The plug goes inside there. Whenever you put these things, what will you do? The people will, the normally, if any person, my lord, will catch hold of the plug. There's no point of that. So there cannot be a mark on that. That will be in the hand only, my lord. The matter of the, so that is why there is the mark on the hand only. There cannot be a, my lord, mark. You will not get the mark on the particularly place because it's not an instrument or any or weapons, my lord. Had it been a weapons, yes, then it is separate, my lord. Stomach, there cannot be a, well, a plug point, my lord. The plug goes into it.
Dictionary খন দিয়কচোন। Dictionary খন। Medical খনে দিয়কচোন। আৰু আমাৰ নৰ্মেল খনো দিয়ক। নহয় এখন নহয় সৰুখন দিলে হ'ব। এইটোনো কি বস্তু? চাই লওঁ। চাওঁ। Ventricular. The tree. A, B, C, D. Fibrillation. 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 And fluid.
Synchronous. Ventricles. Independent. Then the heart side is simple line. The ventricle.
Ventricular.
How?
Antemortem electrocution. Ventricular নহয় নে? এইটো নেকি এখন কেছ ডায়েৰী ৰেকৰ্ডটো not ventricular, ventricular. Page 61. It should be V. Fibrillation. Then heart ceases to pump blood. Fibrillation is when heart ceases to pump blood. When ventricular fibrillation occurs, the heart stops beating. Basically, it is cardiac arrest. Cardiac arrest. It is most commonly the result of myocardial infarction. E2 page maripelai page 61 rows are the parbuga yeah. Okay, hi, Mr. PB. P. Bora.
One decision I have given so far, appeal and executed. 2021 5 SCC, page 283. Two decision.
NIA case.
Regarding the.
Principle.
Appeal against acquittal, my lord, this everywhere it applies everything. I have not, that is why I have not cited these things. Appeal is again acquitted, if, my lord, it's within a very, it'll be a very limited billots, very limited billot. I cannot go beyond, travel beyond this billot. That I have to only stick that, what is this perversity billot? Now perversity is this, the matter of the fact is this 5 lines by all the 6. So and so, so and so, so and so. The second part is this, the medical evidence. The what medical causes, your lordship, that there should have been, my lord, because it's a plug, there's a difference between bone, my lord, instruments and a wire. Had it been, my lord, because normally, when anything, even insect comes also, my lord, it will be a particular one person, my lord. But there, it cannot be a one particular portion of this. Either it is-
That your suggested reaction was not made by the disease according to all these eyewitnesses who were
my lord,
supposedly hardly 1 meter, 2 meter distance inside the same room.
no.
That is what we're
What they
concerned
say,
with.
my lord, see,
He has seen it like this
yes, the see,
at this distance, but they were consistent.
what
They were very consistent,
consistent
is it not?
This 4 lines below what is said. She came out, there is 2 rooms, one in so and so, and they have been using as a drawing room. The deceased used to sleep there. She came out, it is nearer her, because when there's there, they'll be definitely within about 2 meters, 3
Quite
meters away.
brave lady. 6 persons were there already inside the room. Came, put it, again went inside the room.
That is there.
Quite brave.
No, that,
Appears, no?
what has happened, it has,
Temporary murder, I think so, killing. In presence of so many witnesses, he could prove me.
they are not, they are
Appears to
not,
be very brave.
they are not in the room, one are the outside the room.
Call the disease to the inverter room also. And see,
These witnesses are all are eyewitnesses. All are eyewitnesses.
But how, why they?
6 eyewitnesses.
They have seen that she had.
Inside the room. Inside the room, inside the house. Let us, but very brave appears to be. P. Boral and senior counsel assisted by K. Sharma, learned counsel for the appellant. Appellant. Mr. Talwar, you are amicus. Is it really appeal or what? Otherwise, this is 372 appeal.
Yes.
Proviso.
Proviso. 370 proviso.
Okay. MS A. Begum, learned additional public prosecutor for the respondent number 1, State of Assam, and Mr. D. Talukdar, learned amicus curiae appearing for the respondent number 2. So, arguments are heard, judgment is reserved.
My lord. That item last. So much loss for today. I don't wait, my lord.
What to do? Maybe next week.
Tuesday, my lord.
Not Tuesday, you are 1 year, 4 months.
1 year, 4 months, one, but he is about ailing and about 68 years.
In the morning, you have seen 21 years. We are giving priority to that. And that is as per the highest authority.
That is.
We have to abide by that.
That's what I was discussing with the bar, my lord, very unfortunate case in our judicial system or whatever it is.
No, we are going by the period of detention, basically. We have to look into that also.
Then speak what the last time.
That is as per the,
Then maybe next Thursday, my lord.
not Tuesday.
I'll take a chance, my lord. I'll take a chance.
Next week, we will not fix anything because it will be computerized. List the appeal after a week. As due to paucity of time, the appeal could not be taken up for hearing. Item number 8.
Next week, my lord.
After a week.